adjournment. In the seminal case of Metropolitan Life versus McCarson, which is the Florida Supreme Court case that established the cause of action, the court explained how it applied in that case. And it said, the facts as a matter of law are not so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Rather, the insurance company, according to the terms of the policy, had the right to demand proof of ineligibility for Medicaid, or from Medicare. And then it goes on and it says, Metropolitan did no more than assert legal rights in a legally permissible way. As such, Metropolitan's actions are privileged under the circumstances. So, Your Honor, it's not really a defense. It's really part of the outrageous calculus, the outrageousness calculus, that the conduct isn't legally outrageous if there is a privilege or a legal right that's being asserted. And Your Honor, we cite some additional cases in our reply that I'll rely upon in that regard. Your Honor also said that even if this is an affirmative defense, which I don't think it is, the court can consider an affirmative defense if it is apparent from the face of the complaint. Your Honor, we would argue that constitutional rights are apparent from the face of the complaint. They allege a crime was committed. They allege an attorney was hired. So it's not a situation where the court can't consider the defendant's constitutional rights. And in fact, in the case Huzzar versus Gross, which we cited in our papers, it's the first DCA case from 1985. It's a defamation case. And in that case, the court was considering a First Amendment privilege on a motion to dismiss and held that trial courts, upon motions to dismiss, routinely make decisions as to whether a privilege applies to protect an allegedly defamatory statement. So again, in that context, the court held that on a motion to dismiss, the court can consider a constitutional right of a defendant if that constitutional right is their defense.
Okay, well let's just ask. I know you have identified what you contend is one crime, which is to actively assist Brian evade capture, essentially. Assuming, of course, that this is not within the four corners. I mean, we know outside of the four corners, but not in the four corners. Is there an allegation that there was an arrest warrant out for him? But assume, for the sake of argument, that is sufficient for purposes of us to find that there was some sort of active crime, if you will. Is there any other crime that the Laundries have been accused of or could potentially be accused of? Because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Well, Your Honor, there doesn't necessarily have to be a crime. You just have to believe that you may be in jeopardy of a potential investigation.
Well, doesn't the case law talk about it has to be a chain in the causation towards a crime?
Your Honor, I don't disagree with you on that point. What I'm saying, though, is there doesn't have to be a formal investigation. If I left this courtroom and committed a crime and nobody knew about it, I'm not obligated to go confess that crime. Like I can assert my silence for as long as I feel like I need to protect myself.
Well, let me ask you this, because the case law I'm familiar with is in a deposition, the Fifth Amendment would have to be invoked as to each specific question. So, for instance, if the question is, what is your name? You might not have a Fifth Amendment right to not answer that, depending on the context of the alleged crime. So I get back to what is the crime here? And isn't that really something that we need more pleadings to be able to accurately identify so that I have a better standard as to whether or not your Fifth Amendment argument actually is applicable?
I don't think so, Your Honor. Certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they do allege that the Laundries, potentially were trying to assist Brian Laundrie in leaving the country, which could be an obstruction, could be something else. There could be, again, we're not leaving the complaint when we talk about that. And so in that regard, the defendants still wouldn't have an obligation to speak about other things that may be sort of tangentially related to the whole situation. If is potentially a crime involved. I mean, Your Honor, in Miranda versus Arizona, the Supreme Court held the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in unfettered exercise of his own free will. So it's the defendant's exercise. It's not something where, the defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all. Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized in part as an individual's substantive right, a right to a private enclave where he may lead a private life. That right is the hallmark of our democracy. So again, Your Honor, it's not, in Miranda versus Arizona, the court wasn't parsing what questions the defendant can or cannot answer. They said the right is a private enclave where a person can lead a private life. They can maintain that privacy for as long as they're able. Now, of course, like there are certain situations if defendant is subpoenaed to testify, perhaps certain questions could be parsed, like what the person's name is or something, as long as that's not incriminating, which in some contexts it is. This is, again, going to the plaintiff's argument, they haven't alleged that anybody was compelling anybody to do something and they refused or something like that. In that context, everybody has the right to their private enclave. They don't have to come and affirmatively state everything they know about everything. That's just not the way our society works. It's not the way, it's not how the Constitution works. People are protected until they're not. And so that, in my opinion, Your Honor, I don't believe that the Laundries would have an obligation to provide certain information and not provide other information. That they're able, they can withhold all information until it's compelled of them. That's or they're provided immunity by the government or whatever the circumstance might be.
Well, let's put a pin in that right now so I can hear from your opponent. Yes,
Your Honor. And Your Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
May it please the court. Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint, and I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question, and I guess maybe by answering this I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously. They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nichole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what their daughter, where their daughter was. Not only did she not.
Let's get back though to legal duty. I hear what you're saying, that these facts might sound bad, but you know, we're not talking about social mores here. We're talking about legal duty.
We're talking.
So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were, their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nichole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nichole. Going to the issue of a duty, Your Honor, I struggle with that. I admittedly, it's difficult to say what it is, and that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nichole that perhaps Gabby was still alive, with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion, where the court found that there was outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of a teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor, contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because two of the debtor's children have been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, The company delayed authorizing a lung transplant, even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness which might not be considered tortious in other situations can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous. And at this particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued. A lie that gave false hope to Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, the complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous, and what the court said was, "We believe that the appellee's conduct in making false statements," and isn't that what Mr. Bertolino did on behalf of the Laundries here? "We believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress," and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, "the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of Tort Section 46, comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nichole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we know she was our son's fiance, and we hope that you find that body too, or you find her and the family is reunited, excuse me. That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of the state of Florida. I think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located, and they chose not to do so. Your Honor, I don't think there's any question. There's been nothing raised, at least by counsel in his argument, that the conduct didn't cause severe emotional distress to my clients, to the extent that they would suggest and have suggested, well, they were already distressed anyway, so all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries. But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
Well, Judge, I'm curious to find out what conduct it is that the complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record. but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive. I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So, first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly, you can't look at the complaint and determine was there an investigation into them and what were the crimes. So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct. More importantly, the First Amendment doesn't...
Mr. Riley, though, I want to direct you back to paragraph 30 of your complaint, where you say that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed were making arrangements for him to leave the country. So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question is, now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime that if they are making efforts to try to remove him from the country? He's not been charged with anything. He's not a fugitive. There's not, that itself does not suggest that they were committing a crime. There has to be an underlying basis. If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get him out of the country. Is that unlawful as it's pled in this complaint? No. It's not.
Okay.
Going back to the First Amendment issue, Your Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support, do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concerned for preventing government from compelling individuals to mouth support for views they find objectionable, or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech, certain speech. So let's look at Overbay.
Mr. Riley, you have 5 minutes left, sir.
Thank you, Your Honor. Are the Laundries suggesting that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that that she's no longer alive? Do they believe that they would have a personal individual preference for not making a statement that they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance. We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contacted an attorney.
I get back to where's the duty, and certainly there's no legal prohibition on calling a lawyer.
Judge, I'm not going there. I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view, that's why it's in the complaint, goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting they shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca, I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the 5th DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor, I didn't raise this, get time to raise this initially, but I would point Your Honor to another important case, which is MM versus MPS. It's a 3rd DCA case from 1989, again cited in the papers. And although not perfectly analogous, that case is instructive because it involves the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now, the plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress. And the court said, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor.
No, thank you, Your Honor. May I be excused?
Yes, sir.
I don't represent any parties in the second case, so.
That's fine. While Mr. Luca is cleaning up, is there anybody that's going to be here in the second case, which is Nichole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA 2115 SC.
Your Honor, Patrick Riley on behalf of Nichole Schmidt as personal representative of the estate of Gabrielle Petito.
Okay. And has anyone appeared for the respondent?
No one, to my knowledge, has appeared. As Your Honor knows, Attorney Spivey, there was an order entered at the request of Attorney Spivey that because it was the Laundrie family who filed the objection to the claim that was made against Brian Laundrie's estate, they should defend the action. An order was entered appointing them ad litem to defend the action. It's been more than 20 days since I served the complaint on Mr. Spivey, but out of an abundance of caution, I'm giving the Laundries a period of time to respond, although the information that I have is that they are not going to and that a default will be entered.
Okay. Well, Deputy Velez, if you could sound the halls for Barry Spivey as curator.
Response in the hallway, Your Honor.
Okay, thank you. The court deputy advises no response to the sounding of the halls. Okay, well, what's your intentions then in this case, Mr. Riley?
Your Honor, I've never had a situation where quite like this. So I don't think I'm obligated to give the Laundries 20 days from the time they were appointed as administrators ad litem to defend the action. But to avoid any future issues, I'm going to give them 20 days and then I'm going to file for a clerk's default.
Okay. And you requested a jury trial in your complaint, I believe?
I did.
Okay, so we'll then have to have a jury trial on the issue.
Yes, Your Honor, we would be prepared to proceed to trial on that matter quickly.
Okay, well, I mean, it's a little premature relative to no default, but are you looking towards November, December, or what was your trial?
Without my trial calendar here, Your Honor, I'm not certain, but probably more likely sometime in early 2023.
Okay. Well, I mean, hopefully for case managements in the future, you can bring your trial calendar.
I apologize.
Okay. Well, we'll wait and see whether you obtain a default or if someone appears. Obviously, if someone appears, I want you all to go ahead and do the case management order and get deadlines set. And so that we'll get the case rolling. If you end up having a default, then we can set a trial. I don't think we necessarily need a another case management. We've got a November 14th, December 12th, then we'll, in the new year. Let's see.
I can look at my calendar now.
Yeah. Well, I can't set a trial right this second because there's no default.
True. Okay.
But the reality is, because you requested a jury trial, we're going to have to impanel a jury on it, assuming that you're going to proceed with the case. Obviously, if you decide not to proceed with the case, then you don't need to have it. But we'll call a jury, and we'll go from there.
Very well.
It's just, I'm trying to figure out, with all the other trials going on here and which judges are going to be here when, just need to start planning these things out.
I hope that doesn't mean what I think it means, but for next year.
I have no idea which judge is going to be here in 2023. That's the chief judge's prerogative.
Understood.
Yeah. So I will not reset a case management if Mr. Spivey or an administrator shows up. I'd ask that you go ahead and do a case management order and send it in, a report. If it is a default, send my judicial assistant word that the default has been entered and a couple of dates on our trial calendar where you're looking for the trial to be had, and then we'll go from there. Assuming that there is a default, how many days of trial are you anticipating?
1 to 2 at the most. The witness list will be short.
I suspect jury selection will take us a little bit of time.
Well, that's why I was saying 1 to 2, because I think I could try the case in a day.
Okay. Anything else in the second case, Mr. Riley,
No, Your Honor, thank you.
No? Okay. With that, we're going to be adjourned for the afternoon. Thank you all very much for being here, and have a good afternoon.
Thank you, Your Honor. You as well.
Breaking news on WFLA Now. Here's JB Buno.
Arguments on both sides on whether the lawsuit filed by Gabby Petito's parents, you see them there, Nichole Schmidt, Joe Petito, will proceed against the parents of Brian Laundrie, not in court today. Our recap, our legal analysis begins now on WFLA Now. Hey there, everybody. JB here with you, live. Of course, been watching every moment, as you have here across all of our platforms on WFLA Now, Facebook Live, YouTube Live. The court feed is now going to break up, and in fact, you just watched it break up, and let me explain why. The court, our equipment now is going to move from inside the courthouse to outside. We have invited attorneys for both sides to speak to our reporter, Allison Henning, outside of the courthouse in Venice, Florida. So we anticipate hearing from Pat Riley, the attorney who you just heard, making the arguments for this to proceed to jury trial next year. He has indicated to me via text message that he does plan on speaking outside the courthouse in the post-hearing interview process. It's more unclear whether or not Matthew Luca is going to be speaking to our cameras. He has, of course, been invited to do so. We'll, of course, find out, but that's the reason why this feed is frozen. They're moving the equipment from inside the courthouse to outside the courthouse. What you really need to know is that we're, of course, going to stay here with you live on WFLA Now to provide you with legal analysis. Peter Tragos, lawyer you know, is going to be hopping back on the Zoom call here in just a moment to provide his expertise. But let's just kind of go over what has transpired. There was a lot of legal minutia, if you will, that I think that some people were perhaps a bit confused by. A lot of this came down to comparative sort of analysis of other cases that were presented. You might have heard other cases brought forth on both sides because of establishing precedent for what is being argued here in this case. Oh, just like that. Our crew is very fast. So we're now live outside of the courthouse, anticipating comments here from Pat Riley.